All right, let's move to the big controversy and the big fight which is going on between social media giants and the government of India. So what are the major things you need to know about what's happening today? Let me break it down for you. Number one is that the government of India notified rules for major social media intermediaries 3 months ago with a deadline of compliance in 3 months. That deadline was up on the 25th of May. Secondly, none of the major foreign-backed social media companies have complied with this deadline so far. Coup has claimed that it has. One of these companies, WhatsApp, has in fact gone to the court and said that they cannot comply with these guidelines, and complying with them would mean a violation of privacy because it means they would have to tell the government, if asked, who the originator of messages are on WhatsApp. This is in the case of WhatsApp that I'm telling you. On the other hand, ET now has learned that the government of India has written to all the social media intermediaries and asked them for an update on their compliance, saying what happened to the deadline that I set for you. The government of India and the Ministry of Technology has also responded to WhatsApp in very strong terms and has implied that if these deadlines are not met, then the cover, the protection that all of these platforms get will be taken away. Now, what this protection is, simply put, that they are not legal or they're not liable for whatever has been put on their platform. So if someone says something on one of these platforms that can be construed as criminal, the platform is not legally bound to do anything about it. They cannot be taken to court. That cover will be taken away if these measures are not complied with. None of the sides seem to be backing down. So what is the real fight about? What does it mean for us as one of the largest consumers of some of these platforms in the world? Speaking on this evening is Nikhil Pava, founder of Medianama.com, Arvind Gupta, head of the Digital India Foundation, and Neha Chaudhary, director public policy at Ikigai Law. Welcome to all of you, and great to have you on the show. Nikhil, let me begin by speaking specifically about WhatsApp's move. They've had 3 months in effect to comply. They've been asked to remove this end-to-end encryption all the way from 2018, and the arguments are the same. The Indian government essentially says that if someone is putting out messages which go viral and can incite violence, etc., we need to know who started it so we can bring them to book and punish them as per the law. WhatsApp has consistently said that, our technology doesn't permit it and it's against privacy. But today they've gone to court. What does that tell us? Does it tell us that WhatsApp is readying itself for a long legal battle?
Tamanna, I don't think WhatsApp had a choice, to be honest. Firstly, for any government to expect that a platform can re-architect itself globally, because WhatsApp is a global platform, it doesn't have a different set of approaches for different countries. To expect it to re-architect itself globally within a span of 3 months is frankly unrealistic. In the same vein, I think WhatsApp has consistently been saying that it's not possible for them to provide traceability without removing end-to-end encryption. And this is in consonance with many views that I've heard and discussed with global technologists and many Indian technologists as well. There is only one differing view from Professor Kamakoti of IIT Madras, but everyone says that it will undermine end-to-end encryption and therefore it could compromise the privacy of all users of the platform. So they've gone to court to essentially prevent these guidelines from being implemented against them. And there is an argument to be made that this is a disproportionate requirement. There is no problem with wanting to trace an individual if there's a court order or a government investigation taking place. But the question that the courts have to deal with is this disproportionate? Is it all right for forcing WhatsApp to re-architect its entire platform to enable traceability for everyone and therefore run the risk of compromising privacy for all of its users if to be able to catch that one entity? So that's what the courts have to grapple with here. And I think it's good to see WhatsApp going to court. They have not always been while they've spoken for privacy quite often, their privacy policy is something which has been problematic. The sharing of data with Facebook has been problematic, and Facebook has a fairly poor history of privacy anyway. But this is not just going to affect WhatsApp, it's also going to affect Signal, it's going to affect any end-to-end encrypted platform that operates in India. So it's good to see someone going to court.
Yes, sure. Arvind Gupta, you have argued that it's hypocritical of WhatsApp to today talk about privacy, considering that they want to kick users out who don't let them share their data with their parent company, Facebook. And that is a point to be considered. But keeping that aside, do you think that there is any way to regulate when any government in power will insist on knowing who the originator of a message is? Let's come down to the crux of what the concerns here are today. It is that this will be misused. How do we protect against that?
So, Tamana, let me just start by saying something very simple. This is like an exam. The government has been grappling with the questions for very long. It was long due. And you yourself has said 2018. I have dealt with WhatsApp chief executives, and they've, certain changes they made, certain changes they said were not possible. They ended up doing it. But let's put WhatsApp for a second. I'll answer WhatsApp in the second part. I think really this is all about a block cartelization of US big tech. They're all saying we are going to be defying Indian law. And we are going to make money from India. We are going to have our own policies. We're going to implement those policies with impunity. But when it comes to obeying Indian law, whatever that may be, we will defy that. None of the platforms, we are only talking about WhatsApp, have even gone to the extent and saying we have complied with the 9 out of 10 conditions. Or we are following these 9 things. The 10th one is problematic. We'll come back to you. They've not done that. They should have come back and answered simple questions. Till 2 years ago, WhatsApp, for say, didn't even have an office in India, maybe 2.5 years ago. So, this is a question of, I will make money from India, I'll get valuations from India, but as the moment it comes about accountability and responsibility, I will not be responsible. And it's an open defiance. They've, all these other platforms, I'm brushing them all together. They in Singapore, in UK, in US, they all appear before federal courts, before the Congress. In India, they are in mostly defiance. Now, coming to the specific issue of WhatsApp, there are a lot of possibilities, there are a lot of technical solutions, but I give one argument on this very simply put. It's for WhatsApp to find WhatsApp and platforms like that to find something that is acceptable both to the government as well as to them. And it's workable. There should be timelines. But they've not presented that. The government is very clear. We don't want every user's data. We only want when there is, and that's why this equitability between privacy and WhatsApp's encryption and traceability it's not binary. It's not 0 and 1. There is definitely a need to be able to trace messages where there is unlawful content, content that affects foreign relationships, child sex, and all these other areas. So, and there's a lot of Supreme Court pressure on that also. So, I think there has to be a ground that has to be found. But WhatsApp, in its open defiance, and very hypocritical. I mean, we have to call it out. Till yesterday, I was trying to implement a policy where they would share data with Facebook. They're not charitable organizations. I've been saying it for 6 years since the time they've been 7 years since they've been acquired by Facebook. Facebook paid them for a reason, $18-20 billion at that point in time, because there is nothing called a free product. We are the products, and so they are here to make money. And now that they are being put under some accountability, they want to defy that. I think, and we should call them out for that. And I think when so many other platforms have gone ahead, I think
the petition, the WhatsApp petition, I'm going to come to other platforms. I don't know how many of them, if many of them have complied, but most of, at least the US big tech companies, have not complied right now. I want to just look at a couple of points that WhatsApp talks about in its petition, and these are the important ones. They argue that there is no way to predict which messages will be the subject of such a tracing order. And then they say, we would be forced to build the ability to identify the first originator for every message sent in India on its platform by the government forever. Neha Chaudhary, let me come to you. The question is here of trust of intent, isn't it? At the crux of the matter. The concern is that any government of the day, if this is brought into law, can misuse the provision to attack those who say or do something that they don't like, apart from the very obvious criminal acts that, some of which Arvind have mentioned. And these big tech companies want to guard against that. Are they valid in passing that judgment or questioning that intent in the Indian context?
Thanks for that, Tamanna. Look, I think that's a question that, forget big tech, right? I think that's a question that privacy advocates and civil society in the country has been asking for a very, very long time now. The fact of the matter is that we don't have robust surveillance law safeguards in this country today. And this is the subject of ongoing litigation before the Supreme Court and has been for several years now. What the mechanism that the new IT rules will tap into is the existing one that we have under the IT Act, where you have a set of agencies of the government, law enforcement and intelligence agencies that are authorized to issue orders for interception, monitoring, and decryption. Now, the IT Act has language that says that these orders have to be issued, for certain grounds. They have to be issued when it's necessary for these orders to be issued, so on and so forth. And there is a review committee mechanism that is constituted. The issue is that this review committee is consisted entirely of secretaries of the government, whether it's the union government, if it's the union government agencies that are issuing this order, or whether it's equivalent posts held by officials in the state government. And that's the challenge, that you can't have the executive sort of sitting in decision or judgment or reviewing its own decisions. If an order is to be passed for that has implications on the fundamental rights, or the fundamental right to privacy of Indians or people in the country, you have to make sure that it's a lawful order, which is also what the Supreme Court told us in the Puttaswamy judgment. The Supreme Court said that the order has to be necessary and proportionate. I think the challenge now is to define what exactly does it mean for something to be proportionate, and is it okay for the executive to sort of sit in judgment over orders that it passes. And honestly, we don't see a similar system existing in, I think, most, if not all, countries around the world. Several people have said this before me. This is a relic of our colonial past, and we need to do something about surveillance law in this country.
Okay, surveillance law is on one end, but Nikhil, I just want to come to you about what is brewing between the government right now and these social media platforms. Just last week, we had this whole fracas with Twitter. And then, you had from people from the Delhi Special Police Cell going to the Twitter office to hand them the notice. You've had the big hullabaloo about the manipulated media tag. They've faced off in the past with the government saying, take down some posts, Twitter saying, we're not going to take it down, etc. Is this going to be a fight with no resolution in sight? Because these companies have displayed that they have no intent of backing down. What can the government do about it? Because there's been a lot of buzz of a ban. Is a ban really on the agenda?
I don't think a ban is on the agenda, Tamanna, but I think what's happened is that with the platforms not complying with the IT rules, and it's like, as per the IT rules themselves, under Rule 7, they would now have liability for the content that's published on the platforms. So whether they will survive that liability or not is something that remains to be seen. At the same time, and just, I think if you zoom out a bit and look at this entire situation that's been growing not just for this year between Twitter and the government, but I think since 2019, and also between Twitter and WhatsApp, since 2017, I think. What this is about balance of power. So it's about who controls our speech. And as a user, I don't want platforms controlling my speech, but I also don't want onerous government restrictions on my speech either. What stood out for me between the face-off between Twitter and the Indian government in January was that Twitter had claimed that some of the orders that they received from the Indian government were unlawful orders. And particularly, I mean, when you looked at it, when the Caravans handle was blocked, and a publication of the stature of Caravan when their Twitter handle was blocked, I think we would have liked to see those orders and whether those orders and those complaints were legitimate or not. I wish that had gone to court, and we would have gotten clarity on whether the government of India, under the protection of Section 69A, is issuing unlawful orders or not, because they need to be challenged in court now. So I'm glad to see WhatsApp going to court. I hope to see more platforms going to court to challenge these rules. And because I do believe that these rules go beyond this ambit of the IT Act. You've had several news publications also going to court to challenge these rules. And that is, as citizens of this country, that is our right to go and challenge rules that are not in consonance with existing laws. And I don't think the government should be creating rules
that go beyond what the law has. Do you believe the rules, because... Sure. Arvind, do you believe that the rules, because that's at the crux of the debate right now, do you think the rules are an excess, are an overreach? Because that is essentially the question. Like some of them, for example, putting in place a CCO, Chief Compliance Officer. None of the companies or the major companies mentioned have managed to do it. And one of the reasons they cite is that the CCO will have to be liable for anything that goes wrong and will be open to penal action. You know, it may be difficult to find someone willing to take on that responsibility.
So, see, this is, Tamanna, this is the crux of it, that, what Nikhil is saying. While we keep debating about this traceability, encryption and everything else, I have started this by saying that, platforms should have shown the right intent. They should have said that this is a grievance officer, this is a compliance, this is a nodal officer. They've not even done that. I mean, we keep, and as I said, this whole debate has turned out to be this debate about encryption and traceability. But most of them, others who don't have this problem, have also not complied by that. I mean, and these are, my data says that a few non-US based platforms, including Telegram, MyGov, which I used to head, have actually done most of the compliance. Rest, there could be others also on the list, but most of the US-based ones have not. And we have to keep remembering that there is zero accountability. You talk about Twitter's, I mean, and this has been going on for many, many years. But let's say in February, Government of India had no way of saying that this manipulated media will happen 3 days before the deadline. And this whole controversy. But these rules were put in place in February. My question is very simple, that does the person, the aggrieved party, there was one party which complained against the manipulated media. Twitter went ahead, became the jury, the judge, the executioner. They did whatever they wanted to do. The aggrieved party, did that aggrieved party also have a say in that matter? Probably not, because there is no grievance officer that person could reach out to. And that is the whole point that I'm trying to make, that I think we need to have the other processes set in place before and they can walk those 9 steps before they ask for relaxation on the 10th step. They've not done that.
No, but just on that specific thing, and Nikhil, I know, wants to come in, just on that specific case that you're talking about, Arvind, it is also imperative that these platforms flag off something that is said to be fake. So where do they draw the line on that? Aren't they also responsible for what is on their platform? Absolutely. There is nothing, I'm not trying to justify any fake news or manipulated news. There are private platforms. They need to, but in the spirit of fairness,
They need to hear both sides. And that's the limited point I'm making. So while in any political debate, one side may say this was unfair, the other side, and this has happened with Facebook, fact checking everywhere. But the limited point I'm saying is, if I have a Twitter handle, whether I'm an individual user, if I have been banned or suspended, do have a process that these platforms are supposed to follow. And it's really a lot about accountability, and they have not shown that accountability so far. I will go to the extent of saying that I think the implications that they are fearing that will happen from India, will emanate from India, will actually be replicated globally, because everybody is watching what will happen in India. There are a lot of countries looking at the debate of accountability on one hand, and as well as traceability on the other hand.
Just the point, yeah. Nikhil, the point about whether these companies have even made the attempt to follow any of these rules or start a conversation or have a dialogue and say that, we can do this, but we can't do this. Can we relook at this? Is that not even happening? And what does that show in terms of, as Arvind Gupta puts it, defiance of Indian law?
So, Tamanna, just in terms of numbers, right? Let's take the largest platform as an example. WhatsApp has about 550 million users in India. Now, even if they were to receive 0.01% of the users to complain, that would mean about 5.5 million complaints, right? So to deal with that scale of complaints, even if you take 0.01, that's 500,000 complaints. Even at that scale, you would need substantially more time to build in processes, standards, mechanisms to deal with the scale of complaints. That's not to say that they shouldn't have started appointing grievance officers. They've already got jobs out for compliance officers. That entire process should have been executed. But I think the Indian government could have been a bit more fair and given more time for companies to set up these processes. These are rules with far-reaching consequences. When you look at when the GDPR came in, and I know that was much more complex and much more had bigger implications. Companies were given 2 years to basically change their processes to comply with it. 3 months is a really short timeline, and especially in case of WhatsApp, you can't expect a company to re-architect itself.
There's likely to be an extension.
Right. But
there's likely to be an extension, unlikely to be a ban. Yeah. Neha, I want to just come to you on this point of the legal process that we may see going forward. Are you expecting other platforms to also enjoin what WhatsApp is saying today and go to court asking for the pushback of some of these clauses in the intermediate rules?
Actually hard to say. A lot of companies might just decide to wait and watch and see how this plays out, because if the matter does get listed in the court tomorrow, people might just choose to wait and see what the court does. If there's an order from the court that says, hey, we're gonna pass a stay on the rules coming into effect until and unless we figure out what's to be done with this petition that's before us, it's really hard to predict which way this will play out. As to the point of whether or not companies have started complying, look, I think they have. I can't comment, of course, on the information that's available publicly. I can just tell you that we've been advising clients across the board on what exactly the thinking should be around complying with these new rules. I think now that the IT Ministry today has sent out a letter to all significant social media intermediaries and said, hey, please let us know what your level of compliance is. So I imagine in the next few days, if the government decides to make that information public, we might have more clarity on that as well.
We'll be tracking the story in the next few days. Suffice to say that there's no ban tomorrow on these social media sites. And even as this conversation is focusing on the fight between the government and these social media apps, we need to also take a look at the broader picture, because part of this are questions about the user's privacy and our rights as well, which sometimes gets lost in that discussion. I want to thank all of you for joining us on the first big story this evening.